Good morning and welcome to the latest Flexible Space Association Workspace Wisdom webinar. I'm Jane Sartin from FlexSA and I'm joined this morning by Katerina Santos and Kane Glancy from Data Protection People, who we've been introduced to as their clients of one of our Workspace members in Leeds. So they're going to be talking to us today about GDPR, new regulations that have come in, and also giving it a general overview. We can take questions at the end. So what they will run through their presentations. If you've got any questions, please put them into the chat box, but we'll aim probably to take them all at the end after the presentation. So I will get your presentation up on screen and leave you to it and come back for the questions.
Sweet, perfect.
Good morning, everyone. It's really nice to meet you. Thank you, Kane, for joining. So we are here to talk about what is new and how to stay compliant. We have several things prepared for you. We will promise to be brief but clear enough to make sure that you have no questions whatsoever. What we have prepared for yourselves will be give you a little bit of a highlight about what is the UK data protection framework, what is the legislation that is applicable, what is new, because we have actually some news around new legislation coming over, going through the basic concepts of data protection and itself with the principles as well that go along with all the data protection rules. We will talk a little bit about the common mistakes and quick wins in an organization perspective as well as an employee. Finally, the DO Act, that is what is new, what is changing in a GDPR perspective. We had a few questions coming over around CCTV, so we thought that would be very good to go around the CCTV in the workplace, and we could discuss about civilians. And finally, we will go through your questions and anything you would like us to talk through. So, in data protection laws, what is all data protection and what actually are the laws that we are talking here about every single time we talk about GDPR? So in the UK, because obviously the UK with the Brexit left the EU, we have this new GDPR that is the UK GDPR, that is the core rules for collecting, using and processing personal data. So this is the main kind of focus that we professionals or any other person that deals with personal data needs to bear in mind, alongside with the Data Protection Act 2018. That is a set of rules, specific rules that sit alongside with the GDPR. So every single time we have a clause or a paragraph that sets a rule, we go to the Data Protection Act to understand in more, clarify and in more detail what actually that paragraph or that clause means. Alongside with these two ones, we have the PECA, so the Privacy and Electronic Comms Regulations, that sets the rules for anything related to marketing emails, cookies, telecommunications. So everything in this perspective will be regulated by PECA. And as we'll talk a little bit in the end of our presentation, we'll talk about the DO Act, so the Data Use and Access Act. So I will leave it for our further slides.
In terms of what data protection is, Kate, and why it matters, because I think that is an important point, is the whole purpose around why these legislations exist is to not just protect the businesses who handle your data day to day, but it's to protect the individual and to give them effectively fundamental rights to protect their personal data that organizations process on them. That is the main reasons for these legislations, is to regulate and protect the individual and the rights that surround them. All of these legislations that we have here are underpinned and regulated by a body called the Information Commissioner. They were called the Information Commissioner's Office. They're now recently moved over to the Information Commission. Now, that's not necessarily a material change that matters, but that is something to know, that all of these laws are regulated by the Information Commissioner's Office, and their purpose is to fundamentally protect an individual's right.
Yeah, and I think a good point is it actually, as alongside what you're saying, so empowering the individuals, but as well to kind of help the organizations to achieve exactly those rights from the individuals. So kind of setting of the obligations to organizations and providing guidance and how kind of the organization can achieve those rights and how the best to describe them.
Absolutely.
So we have a little, like 3 or 4 concepts that we came through every single time that we talk with any client or any experience in data protection. The first question that we ask is it actually a processing activity? And what is personal data? And if it's actually a personal data issue that is involved. So with this, I think it's important to try to understand what are these concepts, the basic ones. And the big one, I think, is personal data. So I would say that in a very high level terms, in quick ones, will be any type of information that can identify or make identifiable, direct or indirectly, an individual or the so-called data subject. So anything as a direct identifier, such as a name, I don't know, a date of birth linked to an email address or to an address, etc., and could easily identify someone from it, we will consider personal data. And then indirectly, we'll probably say some opinion, some comments that even if someone directly is not identified from it, but is easily identifiable because, for example, me and you, Ken, were in this meeting and we did this report about someone else, a third party, and this third party would read the email, and we knew that this is a party. We will know that is a person. So indirectly could identify this other person.
Absolutely.
What do you think about processing?
Well, it's all about what we're doing with that affirmation, personal data. Of course, personal data, as you said, Kate, is anything that is effectively painting a story and telling you something about an individual. As long as it's telling you something about an individual, then it's likely to be personal data. And processing is exactly what we're using that personal data for. As you can see, we've got quite a long description there as what processing means. That's because it casts a very, very broad net in terms of the scope of what we consider to be processing in the eyes of the UK GDPR. Effectively, it's any way that we use that data itself for a specific purpose. So that could be so many things. So a really common example for using personal data is the process of recruitment, but you're not just using that recruitment data just to offer someone a job. You're also processing when you're storing that data, when you're sending emails back and forth, when you put that CV in your HR files, when say you record these interviews. Processing is such a broad scope in terms of what it's actually looking to capture. And most of it involves, if you're doing anything with personal data, even if it just sits there in your emails, technically you caught under the GDPR as processing it. So it's any sort of activity that is covered on personal data, which is very broad, which can lead people maybe being a little bit confused occasionally on what processing actually means. But if you're using personal data for a function, or if you have personal data for whatever reason, you are caught under that scope of processing of the GDPR.
Yeah, it's literally everything, isn't it? What we can do with everything we can think about will be included, isn't it? And one thing that I would like just to probably add to you is just because we have a question regarding the customer of ours, if it is processing only involved in electronic means or not. So just to make a point that this is literally any type of information, being a physical document, being in electronic means, anything that's kind of meets these requirements that we can just explain will be considered the processing, and then obviously the personal data. Just a final one in the data subject. So is where to who this information that we are talking about relates to. This needs to be a living human being, a natural person that could be identified from this information. So both from the processing activity and from the personal data. I think it's just important as well just to make a point that the UK GDPR does not apply to deceased individuals. So unfortunately, if they died, the UK GDPR do not apply to them anymore. So it's just living human beings. So let's carry on with our favorite part, I would say, that are the data protection principles.
Yes, the principles effectively undertake and apply to every kind of processing we do. So when we look at those concepts above in that previous slide, everything we do in relation to that kind of processing has to abide by what is known as the data protection principles. There are 7 key principles that underpin data protection as a whole. The seventh one kind of being a caveat into relating to them all. The first one is probably the main one for me most of the time. As much as these are all vitally important, this is the one that usually we tail around to the most, which is lawfulness, fairness, and transparency. So it's a fairly simple one. It's kind of three little principles brought into one. Lawfulness means that you can justify that processing lawfully. So under the UK GDPR, there are lawful basis and lawful grounds for processing that personal data. Now, all that means is that to abide by that principle, you need to have an applicable lawful basis, one that applies to the processing that you're doing. Fairness, again, is quite simple in terms of the meaning, in terms of what it means. It's mean processing in a way that someone would expect. We're not doing anything outside of the boundaries of like what reasonably expect when you give that person a personal data. You know, if you go into a website and you complete a form, what you reasonably would expect would happen to that personal data should be what is happening, nothing above and beyond those purposes. And that links into the transparency principle, which is telling people what you're doing with their data. And that should make that processing something that is reasonably expected if we explain that in a way that is simple and clear and comprehensive, which is why we have things like privacy notices. As the existence of privacy notices is to fulfill that transparency obligation in making the processing that we do really clear to data subject.
And I think in terms of the privacy notice, it's true that there are a few requirements that the law provides to us that the organizations as the controllers need to kind of achieve. When we as a service try to review those privacy notice, always the question that at least I do to myself is, do I understand what you're doing and how you do it? And do I feel that is fair and lawful? And I think these are the main questions when we are doing the review of these documents. Sometimes the answers are no, which actually I think is a very, very good exercise. And this is a link to, I think, to the second one, to the purpose limitation. So when we are thinking about a new processing activity, so now we understand the concept of what it means, a processing activity to collect, for example, to obtain personal data, to access that, we need to understand why we need to do that. What is the purpose? Why we need? What is the reason? And when we do it, when we go to the pricing notice to understand the purpose, and this is the reason why we can only use it for that specific purpose. So, for example, getting in mind, for example, the marketing purposes or even the recruitment one, when you establish exactly the purpose of that specific personal data, such as the name, the curriculum vitae, like the interviews notes that you collect from the recruitment, etc., will be just used for the recruitment purposes, and probably if they are successful for an onboarding perspective as well, for several reasons, there will be the purpose that will be limited that processing activity. So will not be, for example, lawful in my perspective, and this purpose limitation principle will not be seen and not be met if you are using these exactly information to send marketing emails to these people. So the purpose are completely different, and you need to only use the data exactly for the reason why you collected it and inform the people in the beginning.
Yes, absolutely. The data minimization principle is, again, relatively simple in nature in the fact that don't collect any more data than you need to fulfill a purpose. So we've identified a purpose. We know what we need to fulfill that purpose. We shouldn't typically be collecting anything that goes beyond that purpose unless we think it's reasonable or necessary. It's quite a straightforward one. It's always the case where I would always look at exactly what you need, understand the scope of what you need to fulfill a task, and make sure that we're not going above and beyond just because it may be beneficial in some kind of other way. And if that is the case, then we may need to look at additional lawful grounds like potentially consent and stuff to collect additional information that isn't necessary for the function that we're trying to do.
Yeah, absolutely. I think the accuracy, I was thinking about what is actually the accuracy, and I think as mirroring the data minimization is exactly very, very straightforward. So making sure that the data that you collected and you are using is actually correct, accurate, and up to date. So in a situation where you have, for example, someone that is your employee, please remove the outdated address and, well, any record that is actually not up to date. Normally, you cannot be a magician, so you cannot guess that, oh, this personal data change or anything like this. So normally this is expected from the people, the data subjects to which this data belongs to inform you that this changed. So if they do, please make sure that your records are up to date, because obviously, even if on an organizational point of view, a lot of concerns come around it, particularly they do not receive your communications, anything like this. So you can imagine.
Yeah, absolutely. The storage limitation principle is a big one. It can also be known as retention, which effectively means don't keep personal data for as long as necessary. These are typically underpinned by legislation or by industry guidance. You're not alone in making these decisions. Usually there's a lot of rationale that goes in behind why we keep something for as long as we do. For example, employee data, we usually hold it for 6 years after the termination of their employment for the purposes of potentially needing to have documents for legal proceedings. But that's the storage limitation in a nutshell. Is we only keep data for as long as it's strictly necessary. We don't just hold on data for a just in case basis, or we definitely don't hold data on a permanent basis.
Definitely not. And I think I would say that probably from all these principles that is two missing, but I think this one is our big one,
Yeah,
isn't it? Is
for sure.
where all the problems normally are brought. Normally, experience talking is clients came were saying, "Oh, but we need this data just in case. What about if this happens? And if the client does any complaint or anything, we might need the data. You need to justify." So there are, in terms of like advising, there are no kind of specific retention period for anything. You can keep it if you can justify it, and if you can, well, that's good news.
And great, yeah.
So going through the integrity and confidentiality, just keep your data safe and secure. So as a controller, you have the obligation by default, by design default, to bear in mind all the technical and organizational measures to make sure that the data is collected and processed, and after that deleted or returned to any other the person, that they are safe and they are have the safeguards, meaning, for example, use encrypted devices. If you have any physical documents, do not let them stay in your desk. Please put it in locked cabinets or just shred them. Within your devices, if you can, multi-factor authentication. Do not tell anyone about your passwords. Use a safe password, not just 12345. So everything around these kind of technical measures are important, as well as organizational. So in terms of policies and procedures, bear in mind that you need to follow them as a controller. And normally this confidentiality clauses are within your employment contract as well. We are expected to see clauses like this, but it's very important to everything that is discussed within your own workplace stays in there, not goes outside.
Yes, absolutely. And then the accountability principle is what underpins all the rest of these
Yes.
principles, in saying that you must be able to prove as an organization why you're doing what you're doing. So if somebody ever comes to challenge a process and activity, you need to be able to demonstrate exactly how you've met all of these principles, on top of showing how what you've done is compliant with all the legislation that we've referenced above.
Yeah, they're all connected, aren't we? I was just like thinking when you are
They do all
trying to do
connect.
like some preparations, like, okay, how can we explain without touching the other principle? Because in the end of the day, all of them are always connected.
Absolutely.
So moving forward, and I think this one will be a little bit juicy, that is the common mistakes. So this is what we deal in our daily basis as a consultant. Um, I think, to be honest, these are the common mistakes that we felt that are very, very common within the organization and both the employee's perspective. I feel that probably leaving screens unlocked or any paperwork exposed, even when you left the office. Don't forget that probably you have cleaning services. They will access your information. They will access your physical documentation, and they do not adhere to the same policies and procedures as you do as a staff member. So this is a very important thing. And leaving the screens unlocked. I had the experience visiting an on-site client that was members of the public had literally access to what was going on in the screen. So not even any relationship with the organization. So please lock your screen, clear your desk, and leave it completely untouched.
Yes, no, exactly that. We have some similar things into what we referenced that tie into the principles. So keeping data just in case, as we referenced, no justification for just in case. It's usually not strong enough. Set clear retention periods. Follow industry guidelines. There are a lot out there. There's a lot of legislation that also help underpin these kind of things. I understand retention is a difficult thing to do for organisations. We do that a lot, but setting clear retention periods and running that through the business is a really solid way of handling that. Again, collecting more data that's needed, as into those principles that we've already talked about. It's all about making sure that everything we do links into those above 7 principles.
Yeah. I think one of them that is quite connected to the accountability one is the training. So one of the things that we normally see in terms of like training staff, and when we do projects, understand if people are trained, normally the answers are, we never received any data protection training, for example, or we did it once we were onboarded, but then after that, after 5 years, never again. Or they did with a quiz of 5 minutes kind of thing. In our perspective, there are a few things as we can see here that sometimes is not very straightforward. And so the training of the staff, so aside from all the theory, all the guidance, etc., should be a place of where your knowledge should be challenged, and you should have a room to actually expose your questions and have answers. And I think the training is exactly, the number one room for that. So please be trained. If you are a member of staff and you feel that you don't have enough knowledge of data protection that you should because you work in the marketing field or in the sales field or HR, please ask your employer to provide you with that training. Or if you are not happy with the schedule, please just make something. Yes.
Absolutely. Should we move on to the doer now?
Yes, I know that you are excited for this one. I knew.
Absolutely. So the doer
The floor is yours.
known as the Data Use and Access Act. So it's been a bill that's been passed around in Parliament for the past year or so, a little bit longer. And what it effectively is legislative reform for the UK GDPR, the Data Protection Act, and the PECA. So again, all those legislations that we referenced at the start. What it aims to do is make practices easier. It's trying to help people understand the initial interpretations of these legislations, because we were guided quite heavily by the ICO, and they wanted to effectively make sure that we have a lot of this legal basis that we've got in terms of guidance within legislation specifically. We're going to talk, there's a lot of changes in the doer, but we're mainly going to talk about most of the changes that are going to be relevant to you guys. Some of it includes very minor clarifications or some actual operational updates. So the first one we have is in relation to subject access requests. This is mainly around the changing of wording more than anything. It's stipulated now into law that there's a new response time. So that's 1 month from the latest of either getting identification verification, from charging a fee, or from when the request is made. Now, this is something that's already been heavily guided by the Information Commissioner. It was a sense of just putting this into writing now and making it effectively lawful, and you have lawful grounds of being able to say, this is how we dictate when the response time starts. You can also delay responses, so they call it stopping the clock until identification is confirmed. So typically you'll receive a request and then that clock will be stopped for that period of time. And something new also is required to carry out reasonable and proportionate searches. Now, this is still typically in the ballpark of the controller to define what they determine to be reasonable, but it now gives organizations the justification to say, we believe the search that we've done for the site is reasonable and proportionate due to factors like how many members of staff they had working on the SAR, how much data they had to search, the systems they had to search. So these are the changes that have been made into the doer. However, these are already changes that most organizations have been doing due to guidance from the ICO. Kate, do you want to take the floor as a
Yeah,
right to complain?
sure. So the contrary to the subject access request was already in the guidance, so it was just to impose guidance to the law. The right to complain is something that probably majority of the organizations already do it, but actually was nowhere to be seen. This is the right to complain. So what happens now is that the data subject, so the individuals can now complain directly to the organizations about any infringement of the GDPR. So in a case, for example, if you do believe as an individual that certain organization do not meet the requirements of the privacy notice, so the fairness, the transparency, the lawfulness that we spoke, or any of the principles are not met, you now have the right to go to the organization and say that you complaining and you're raising a complaining. That this means, on your organizational perspective, that you should have a complaints procedure, because this is something that is new. So you need to prepare yourself as an organization to embrace this new right, aka your obligation as well. Meaning that you need to acknowledge the complaints within 30 days. Any kind of response or any outcomes on updates should be said and should be documented as well internally. And if needed, you need to report, in principle, if the information commissioner comes to you, you need to report how many complaints numbers you received for that amount of time. So unfortunately, we from the information commissioner office, we are still waiting for more guidance in terms of what we are expecting, or at least how these procedures should look like. But for from experience, and to be honest, when we are doing these presentations to customers of ours, we came across as, oh, but we already do it. We already receive the complaints. We already deal as a complaint. The individuals always have the right, in our perspective, to come to us if they need something, and then they go to the ICO. I think probably this one will be as well to kind of relieve a little bit of the ICO complaints, so for them to have time to actually do their job now. So let's see how this looks like. But I really do appreciate this one. I feel probably this will take more work on the organizational point of view, but I think will be very, very straightforward. I think so.
Agreed. We have some material changes to PECA and cookie rules. So as we mentioned above, PECA is the legislation that underpins direct marketing and cookies. And one of the main things that have been changed, probably two main things in particular, is one around cookie banners. So everybody that has a website typically has a cookie banner, because cookies are used on a website. Typically, cookies fall into two categories. You have your strictly necessary cookies. So these do not need consent, and they're essential for the running and functionality of a website. And then secondary, we have any other cookie. So a lot of your analytical performance-based cookies. Now, what the doer has done is change these secondary cookies, these cookies that typically need consent, under the cookie banner, and have changed which one of these actually do need consent or not. So as you can see in the list here, any cookies that we use for technical information for security or fraud detection, anything for the functionality or website appearance, if we're collecting stats for the actual improvement of the website, or if we need to deliver any emergency assistance, none of these cookies need consent anymore. So what that means is that a lot of organizations will need to revisit the cookies that they deploy on a website and ascertain which ones they actually need to then move out of the cookie banner as no longer needing consent for functionality. This is because I think a lot of the cookies that were being caught in cookie banners, when rejected, would actually have a little bit of a detriment onto the actual functionality of the website. And that's not what the legislation was written for. It was written to stop cookies that are effectively going to scrape and track your data over loads of different websites. It's meant to give you the choice if you're okay with that. So that's quite a big change materially in terms of the doer. And I think that's probably one of the bigger changes that organizations are going to see. And one of the things I'll heavily recommend is that a lot of people do a review of the cookies deployed in their website to make sure that they can now shift any of these cookies into now cookies that don't need consent, which should be really helpful for a lot of people that are deploying websites.
Yeah, I agree. I think one of the juicy one that came to our attention as well was the fact that the legislature decided to kind of redefined what means a call and electric mail to include failed messages, which means that the intention now counts, isn't it? Like for
Yes.
kind of unfair, like, oh, let's talk about breach and stuff. Now, your intention of, for example, a missed call or even a not delivered message or the not delivered email will be counted as a probable packer breach. Well, if there is any audit or any complaint against yourselves.
Absolutely.
So let's see what are our recommendations about all of this. So I was trying to talk a little bit about the main one, big changes that the DUA Act presents to yourselves as organizations, and as well, obviously as an employee or staff members, you need to adapt to the organization's policies and procedures. So we tried, it's true that some of them, if not majority, we are still waiting for some Secretary of State insights. So the SaaS beta is already in place, but some of them we are still waiting for more news around it. So in terms of recommendations and next steps, we kind of tried to split this in short and mid-term in terms of what actually steps you should kind of look for. So in terms of any updating of policies, notices, the SAP procedure and the complaint process is something that in short term, meaning as soon as you can now, you should do it. So in terms of the sub procedure, exactly as Kane mentioned, including in the research, I'll do my search needs to be proportionate. Now we have this time, we have the month, the clock stops, etc. So we're including all of this. In terms of the complaints process, identify the people that will be responsible to the response of these complaints, understand if you have a new email address or not, how will be the process and internal procedure to kind of respond to these complaints if they come. In terms of midterms, we'll have this are completely linked to other changes that the DUA Act brought related to the legitimate interest assessment. So very short, there are now the legitimate interest that is considered as a lawful basis, so the legal basis that justifies the reason why you are collecting or obtaining that data from the individual. Normally, it's very, very high recommended for you to carry out a legitimate interest assessment. Just make sure that your interests as an organization do not override the data subject's interests as well. So now what the law says is presents with an annex saying that there are recognized legitimate interests, that there are no need for you to carry out any assessment because it's clear that is in the best interest for both parties. And is not ever enough to kind of highlight the staff training. Please train your staff with these changes and with any GDPR kind of thing. I think at least the very, very least yearly. And yeah, probably ongoing monitor the ICO guidance and document any decisions that you made. Because as mentioned before, we are still waiting for that guidance. If you go to the website, there are a few things that already changed, but unfortunately, there are a few notes still. We are updating this page. Please keep you on the loop.
And then I think the last kind of slide we want to talk about until we go into sort of like and closing the session off and fielding some questions was around CCTV. We know how popular CCTV is in relation to compliance. We got a lot of questions surrounding CCTV, and there's probably quite a quick guide in terms of the main things that we think you guys need to focus on. The first thing is, again, similar as I've mentioned, always take into account the principles. The principles underpin everything we do in relation to personal data. So only use CCTV for specific and lawful aims, things like preventing and detecting crime, safeguarding your staff, all very reasonable purposes, lawful basis. Typically, this is legitimate interest. It's very hard to find another applicable lawful basis in an instance like this. We'd always recommend you complete a data protection impact assessment to consider the overarching risk of CCTV, and that will help you actually look at the principles as a whole as well and making sure that you're achieving those. Transparency, use clear signages. We've all seen the signs, CCTV in operation here. These are the kind of things that we're looking for. Data subjects need to be aware that they're being recorded in some kind of way, unless that monitoring is going to be covert, but those have slightly different rules. Data security, so restrict that access to the footage, encrypt the storage of the data, and maintain access logs so we know exactly who's going in and accessing what, as well as making sure that that access is very limited to a small group of people or just one person if possible. Retention, most typical footage is kept for around about 30 days, kind of rolling on and off. We can usually keep it longer if we need to take that footage out for if something has happened in relation to a crime, or there's an insurance claim, or a court order, or a request for that footage, then we can justify holding that data for longer, but typically it usually rolls on about a 30-day basis. And then workplace monitoring. So if we want to monitor employees within a business by using CCTV, requires very strong justifications. Again, I would highly recommend that you complete a DPIA. Obviously, it's all about balancing the rights of individuals, and workplace monitoring could sometimes be difficult to justify depending on what exactly we're looking at. So if we ever want to do anything, or we're doing anything like that, I would retrospectively complete a DPIA, because there are some risks that are beneficial to cover.
Yeah, and must be clearly communicated that the employees should be aware of it. And I think it's important just to make a distinction that monitoring is not the same as surveillance. So it's completely different concepts that sometimes, unfortunately, they kind of link together. And I feel that the main difference is carrying out the impact assessment before the installation of any CCTV. So it's exactly the data protection impact assessment that I think the main thing is always assess the risks before you decide to do something. And I feel that within the CCTV is really highly recommended, particularly in a work environment and the workplace environment, because there are a lot of risks, as you may understand, involved in here. So as the last slide, we just gave some final recommendations just for you, very, very straightforward. Just keep it simple. I think is something that unfortunately a lot of people come to us and say, "Oh my God, data protection is so hard. It's so different concepts, so difficult concepts. How can we like keep up with everything?" I think just keep it simple and just do what you need to do. And as an individual and a data subject perspective, if you need to think, I do like to always advise my clients, if put yourselves as an individual point of view. So if you want to know exactly how your data will be handled, exactly what they are doing with your data, think about it and do and put it in practice exactly for the other individuals that you are dealing with and with the data, personal data that you are using. Don't want your data in the third parties that you have no awareness completely. You have no idea what they're doing with it. Just keep it simple, very simple terms in your privacy notices.
Absolutely.
I
And
think
then in
that's my
terms
big one.
of, yeah, no, absolutely. Very, very key tips. Keeping it simple is the best thing. Putting yourself in the data subject's shoes is huge. Reviewing these often, in terms of reviewing your practices often, and then staying up to date with the ICO. As we say, it's probably more important than ever to be watching the ICO's guidance in terms of things like the Doer Act. So
Yeah.
it's good to keep an eye of things that are being published in relation to that. The ICO is there to guide their regulator for a reason. So staying up to date with the guidance that they're bringing in to do it will really help you implement some of the changes that we've referenced as well.
Yeah, I think probably final notes is always I would like to say keep it simple, be transparent and very open what you do, and stay tuned in terms of news, in terms of guidance, in terms of anything that goes around. And yeah, I think this will be my three
Yeah.
big ones.
No, absolutely.
And I think yes. So we came to the end. I'm not sure if there are any questions. I hope you did. I hope you liked the session.
No, absolutely.
Thank you. There was a huge amount of information packed in there, and I'm sure, but I really simply explained. So thank you very much for that. I'm sure people have taken that a lot from that. So we've got a few minutes for questions. We've got a couple in so far. So firstly, you talked a bit about video, but in terms of CCTV, but would a video or photo form part of processing?
Yes, typically. Depends, of course, what that photo or video is of. If it's something that would reasonably be personal data. So as we said, CCTV, it's going to cover the comings and goings of people. So that's going to cover their data in that sense. Obviously, photos of things like a building. If you just take a picture of an office space, for example, there's nobody in the office space. Of course, that's not personal data in that sense. We're looking at it being processing where there is reasonably personal data involved. Of course, if there's individuals in the scope of whatever the picture or the video it is, then we would consider it processing under the scope of the UK GDPR.
Okay, thank you. Let's bring us back onto screen. So someone's asked if you can recommend any providers for GDPR training. Is this something that that your company does?
Yes.
Yes, it's
I'm not going to
indeed.
expect you to recommend anyone else then.
I will leave probably this one for you, Jane.
So I'm sure there are many companies out there, but that's certainly something that data protection people do, and we've just shared.
Yeah, absolutely. And if you are interested, just drop us an email and we can liaise yourselves with our training manager.
Okay, thank you. So someone said, can I be reminded of what DUA, LIA, DPIA, and ICA means?
Yes, of course. Sorry. The DUA is in relation to the Data Use and Access Act, which is a brand new piece of legislation which reached royal assent. I think it was on the 19th of July 2025. LIA is a legitimate interest assessment, which is a effectively three-part balancing test that you do where you identify legitimate interest as your lawful basis for processing. It's an additional thing that you have to do to rely on that basis typically. DPIA is a data protection impact assessment, which is a balancing of risk for any high-risk processing activity. And what that's for is to effectively look at the risks of the processing and attempt to mitigate them, or to even identify them and accept that risk of the business. And the ICO is our regulator and commissioner for data protection, so the Information Commissioner's Office. They have now moved to something being called the Information Commission, which is the same thing. They're still the same, they just have a slightly different name, but they are our regulator and they are responsible for giving us guidance as well as enforcing actions onto organizations who don't comply with data protection legislation.
Okay, thank you. Someone's looking to use facial recognition. Does this pose specific problems?
I would say this is always a juicy one. Yes, the answer very straightforward is yes. So the facial recognition technologies and every tools that kind of go around it process one type of personal data that's called biometric data. So something that we kind of didn't go through our concepts, but I think is a good way to include it now. We have the normal personal data such as names, email addresses, etc. And then we have what is called special category data that needs extra protection because can lead, if goes to the wrong hands, for example, can lead to discrimination on a very, very wrong consequences and very harmful. So in terms of like problems, and because we are talking about biometric data and kind of for identification purpose, a lot of things we need to be considered. And now I will give your thoughts to the 7 principles that we spoke before. So I would say we need to understand the first one is the reason why you need that facial recognition. So probably will be for security purposes, to recognition and identification purposes. But you need to understand for example, in a workplace or even, I don't know, in a public space, there is a very strong intrusion of a privacy of an individual. So there people may feel watched and kind of monitored in a way. So what my recommendation 100% to be the first thing to do is carry out, now you know what I'm going to say, a DPIA, a data protection impact assessment. Make sure that you carry out the risk assessment, identify all the risks that could be involved. Risks this could be something like other people feeling watched. Are they aware that this will kind of be used? Do we have a lawful basis to do that? Probably can be consent or can be under substantial public interest, depending on the purpose. That's why I was saying that all the principles are connected. So make sure that you have a risk assessment in place. Make sure that you are happy with the outcome of it. And if you want, or if you have any questions or any doubts, normally is because something is wrong. So don't do it.
Yeah, good final words there. So a couple more questions. Can an admin fee be charged to the data subject for accessible large requests? And if so, what's classed as a reasonable fee?
Yes, typically. However, it's quite a high bar, to be honest, and not one I really see rolled out. It's a question that people always kind of flirt with the opportunity to do, and they never really tend to go ahead. Now, typically, you can charge a fee for a SAR for two reasons, and it's if that SAR is manifestly unfounded or excessive in nature. These are two certain that come from the UK GDPR. I'll copy the Data Protection Act, actually, which effectively means manifestly unfounded is if the request is effectively there to disrupt the organization, but that intention has to be kind of made very clear. It is a very, very high bar. You need to be so certain as to the fact that the individual has they don't want to request their right. They don't necessarily want to make a SAR. They're just trying to disrupt normal business operations. And then manifestly excessive, which is if someone's made multiple requests in one go, or they're requesting the same kind of personal data. So they're making an additional request. So you've already provided them with that data. And if you've determined any of these two to be the case, then yes, you can charge a reasonable fee. Those fees mainly come from so admin time, so time actually done trying to undertake the SAR, usually for things like printing costs or like sending costs, specifically where people ask for like physical copies for a SAR. Usually charge for like printing cost or like sending that through like Royal Mail or whatever. Usually those are typical things that people charge for. There's no hard and fast rule for what is considered a reasonable fee, just because it's determined on loads of things in relation to the SAR. The one thing I would say is don't charge a fee for every SAR. I've seen a few organisations try to do that. The ICO doesn't look very fondly on that kind of activity typically.
At all.
So I would only really do it in the instances where you believe it to be excessive or manifestly unfounded. And I understand that could be a hard thing to determine and dictate, but the ICO does have some fairly solid guidance on how to dictate if that is the case.
Is any allowance made for the size of the business? And looking back, I've worked in an organisation that had a dedicated data protection officer amongst its very large staff, where of course many people running flexible workspace just have 3 or 4 staff.
Yeah. No, definitely can be the case. It's one of the factors that the ICO give in terms of this is how we determine how we make a reasonable fee. So the size of the business comes into it, the size of the SAR comes into it, as well as, again, anything in terms of like admin costs. So as I say, printing, any special tools that you need to use, obviously the actual time of your employees.
Of the employees.
We know a lot of people that do these roles tend to have like multi-roles in terms of data protection. So it's not usually their only role. So it's stripping them away from whatever that role is and then giving that focus to data protection. However, as I say, most of the times for a lot of my customers, no one really tends to do that in terms of charging a fee, just because manifestly unfounded and excessive is actually a refusal for a SAR. So you don't necessarily have to run that SAR if it is unfounded or excessive. So most people either go to that option or they realize that it doesn't necessarily fit that definition of unfounded or excessive.
We for example, had the case with a customer of mine that was a housing association, and a tenant submitted a SAR request, and the records. That's why the retention is so important in actually to comply with them, because I think is when within the SAR come in is when we see, oh my God, we have so many data, and actually in the end of the day, the data subjects actually have the right to have that data and the confirmation that you are processing that data. But it's for me to say that the individual did not have electronic mail, so needed to be by post. And we are talking a lot of data. Unfortunately, we tried to kind of make it broader and broader, but again, they wanted everything in those very specific terms. So the decision that was made by the compliance team in that regard was actually okay. So because it needs to be physical documents, we are talking about a 15 years registers type of data, a lot of copies, a lot of printers. So we will charge you with a reasonable fee. And actually the math that we came to the end was exactly what you're mentioning, kind the administrative costs. So we did like kind of how much did a kind of a print in black and white cost, and the working hours as well of the individuals. But to be honest, in my last year and year and a half with DPP was the only one that I came across as charging something. Yeah.
Okay. So there's a question, how do we ensure third-party referrals have given their approval to contact them or use their data? I'm not sure, it's certain of the context, but certainly in our world, there are office brokers, which are kind of middle people between someone that's looking for an office and then the people running the workspace. So it's that sort of arrangement.
All right.
Okay. So I think, I mean, my initial thoughts is, if someone gives you third parties, names, email addresses, contact details, anything, you automatically are processing personal data. So this will mean that, again, everything that we spoke about, you need to have in mind. So receiving the data, if you have the lawful basis, you have a purpose, why you are doing it. Ideally, is expected to that person, that third party, to know and to be expected to be contacted by you. So I would say that probably the question that I will first ask is to the person that is giving you, provided with the data, has the third parties gave the permission to actually share those details? Do they understand, for example, that they will be contacted by us in this case? And if they can be confirmed, is that actually the person is expecting to be contacted. I think probably this will be, I'm not sure if I replied to the question, but I think probably this will be my main ones, because aside from that, aside from you making these questions, and obviously the privacy notice being transparent and everything, bear in mind that the information can be included in the privacy notice does not mean that the individual, for everything that your organization will do, needs to be every single time of the way be contacted by it. So this information can be all populated in the privacy notice. So is it one step to be confirmed, for example, or actually directly raise the question to the third party and asking if they are expected to be contacted by you, I would say.
Okay. Now this is quite a specific question, which I'm not so let me read it. Do you have any information on the crossover between a SAR and the regulations around anti-money laundering? This will be regulations, especially where you feel there is suspicious activity. So our industry has some duties around anti-money laundering. Is this something you can comment on at all?
Yeah, I think so. I think it would depend in the realms of which of the content of the SAR. If there's information that's obviously going to disclose the fact that we believe that there's some kind of suspicious activity, typically that's information that would be considered like exempt under the Data Protection Act and its exemptions for SARs, especially if it's in relation to any form of investigation that's being launched. If we believe that we've identified some suspicious activity, then it's obviously a SAR is not there to like give individuals like a foot up. You know, if we're processing data because we need to launch criminal investigation, or we're talking to the police about criminal investigation, it's not there to give them that information so that they're like a step ahead almost. You know, the exemptions exist for those reasons, to protect businesses, especially in their activities and investigations for suspicious activity. So I would believe so. I haven't seen anything that on the nose in relation to anti-money laundering yet, but I would imagine it would follow the same kind of rules in that sense. But it's probably the case that if you have any questions, you can contact us. We'll definitely have some guidance in relation to that if that is necessary.
Okay, thank you. And this is perhaps something that we have the Flex Compliance Forum meetings, so it's maybe something that we can pick up with the authorities that are present at those at a future meeting. Is there any standard wording and a place to source this wording regarding data collection to be included in terms and conditions that covers some of the changes mentioned today?
Well, I'm not okay.
Are you a bit stuck? Well, in terms of the changes, in terms of the doer, no one's really come out and like actually done anything in relation to changes yet. I mean, we've been working with our customers to update policies and procedural work, but a lot of the doer changes have been sort of rolled out very slowly, and a lot of them not yet. So a lot of people are kind of holding fire because they're waiting for the ICO to say, okay, this is what you put in. As I say, I've already been working with a handful of customers to get those things in place without the shameless plug. In essence, it would be things like external consultancies that would have those kind of resources. In terms of information into the data collection, presumably that's in relation to like a privacy notice. the ICO does have a template privacy notice that you can use. I don't necessarily like it, but it is there and it
No,
does cover
it's
the
terrible.
requirements. Yeah. I'm not necessarily the biggest fan, but they do have templates out there like that to use. And again, other external consultancies who do a similar thing in relation to data protection do have templates that are usually like readily available, very quick. They can sort of pass you it over. It's a lot of like inputting the data that relates to you guys. So that's probably the best thing I can recommend in that sense.
I think just to add, I'm sorry, I did not understand the question initially. I'm really sorry. I think probably one thing when we are reviewing now our notices and policies and procedures, something to include could be something if you want to change anything mirroring the data, the due act, could be something you can mention it. For example, when you in your introduction point of view, when you're mentioning that we are committed to protect your personal data within the UK GDPR and UK data protection laws, etc. You can make a reference that obviously will be temporary, but can make a mention of these privacy notice. Bear in mind that was updated, mirroring the new kind of legislations, particularly around the due act, this and that. One thing that we're saying as well is obviously because there is a new right of the individuals, update your rights list in terms of the right to complain and your procedure as well, etc. And in terms of like aside from templates and wordings, exactly what Ken's saying. I mean, the ICO has some. Unfortunately, we don't love it, but yeah, I think aside from that, it's waiting for the guidance to come over. I'm sure anything will come.
Okay, well, thank you. I think that's a record number of questions for one of our webinars.
Yes.
You've answered them all brilliantly. So thank you very much for giving us so much of your time and expertise. This webinar, as with all of our webinars, will be posted onto our YouTube channel. So if there's anything that people watching want to see again, or if you want to share it with colleagues, it'll be on the FlexSA YouTube channel later today. So huge thanks, Katerina and Kane, for sharing your expertise with us. We'll have a little break now for our webinars over the summer, and then we'll be back in the autumn with a new range. Always interested to hear what topics people would like us to cover as well with these. So do get in touch with the FlexSA team if you've got any thoughts on that. Thank you, everybody, and have a good rest of the day. Goodbye.
Thank you very much for your time, guys.
Bye.